Hey everyone, welcome to our employment law episode today. I'm David Brannen, disability lawyer and employment lawyer here with Resolute. Today we're going to be covering a critical topic, how to appeal an employment insurance denial from Service Canada. This was, again, continuing addressing kind of issues that readers of our email newsletter have sent in. So we're covering this for someone who requested it today. Hopefully that person will be here in the chat and can ask more questions. Now, a lot of people feel discouraged after getting an EI denial for employment insurance benefits, but don't give up. There is a process for how to appeal. We're going to go through that today, and hopefully we'll shed some light on this process for you. Let's start by looking at some common reasons for EI denials. So just to be clear, EI is employment insurance. This is what's available for people when they've lost their employment. It can pay you benefits up to a year in some cases, but you have to have paid into EI through payroll. You have to have a certain amount of hours. I won't go through all the eligibility today, but I think it's 600 hours over a certain period to be able to get the full EI benefits. Now, oftentimes people apply for EI benefits and you can be denied for various reasons. Let's go through some of them here. And these are all reasons that you have ways to appeal and get around. So the first most common one that you will get is misconduct. Service Canada may believe you were fired for misconduct. If they do, misconduct is a reason you can be legitimately denied. If you were fired from your job for misconduct, that is a legitimate reason to deny EI benefits, unfortunately. Now, I guess they don't want to reward people for misconduct. Now, sometimes the employer will indicate misconduct on your record of employment, but there may not actually be misconduct on your part. Even if the employer alleges there is, Service Canada will do its own investigation, and you can certainly appeal it. If they don't do their own investigation or if they just deny it, you can appeal it on the basis that there was no misconduct by you. You were fired for whatever reason, but it was nothing to do with any serious fault. It's not just some minor misconduct. If it involved a minor mistake or misunderstandings and that kind of thing, it would have to be like very willful, serious misconduct in order for you to be denied EI benefits. And in most cases, that's just not going to be the case. Now, some employers will say that you voluntarily quit your job. If you quit your job, then you're not entitled to EI benefits. That's something else people don't always get. Now, there are situations, though, where you may have quit your job, but it really is more of a constructive dismissal. And if you can prove that it was a constructive dismissal situation, like you were being harassed or the employer made major changes to your job without your consent, these can be situations where it is not a voluntary quit, that Service Canada can recognize this as a constructive dismissal and will pay benefits. So in these kind of situations, you may have to give more information to support this kind of claim that you're making against them, or making to say that you didn't voluntarily quit. Now, sometimes this is a more tricky one, but if you have insufficient hours, you do have to have enough qualifying hours to get EI benefits. Sometimes if you know you did have sufficient hours, it may be that your employer recorded it wrong. Like, there can be errors on your record of employment for sure. So if that is a situation, you can appeal the decision. If your employer is not cooperative, you can also submit pay stubs and other written confirmation to show that the ROE, the record of employment that it was prepared, is incorrect. There can be errors with ROEs just through negligence. They are just produced by whoever's doing the payroll for the company, so they can be wrong, and you should appeal it if you think it is incorrect. Now, another situation is you might have been misclassified as maybe like self-employed or something like that. If you were actually working under someone else's control, had a schedule, used their tools, you still may qualify. And so even if you and the employer think that you're a contractor, you still may be classified as an employee. So it's worth appealing this if you really are in a situation where you are what I would say like a de facto, for all intents and purposes, you are an employee, even if the employment situation has been set up as you are a contractor. I've seen this in real life. I've worked at different law firms where the law firm tried to classify the lawyers as independent contractors, but they were not. So they ended up being classified as employees, and the law firm had to end up paying like maternity benefits and EI benefits when terminating the employees who were lawyers. Okay. Now there can be issues around there alleging that you were not ready. If they believe you were ready and able to work, your claim could be denied, or that you weren't, ready and available to work. So to get EI, you have to be ready and available to work. So if there's some reason that you weren't ready, or they believe you weren't ready and able to work, they can deny your claim. You would have to show that you were ready and able to work. You can do that by showing that you had job search activity, and that any limitations they thought you had were temporary, and that they're no longer applicable. That's how you would get around these availability kind of denials. Now, the last one, unfortunately, does happen: late filing or missed reports. If you miss deadlines, it's quite serious with these EI cases. They will allow extensions, like not minor extensions, if you can show that you had good cause for missing the deadline. This could be some misunderstandings, illness, or other reasonable issues, but you do want to act as quickly as possible. All right, so if you have been denied, the first step is very much the same as with the steps are the same as with CPP disability, except the deadlines come up faster. So the first step is a reconsideration. This is the same kind of process you would use for CPP disability, except that you have 30 days, not 90 days. You submit the reconsideration form just like you would do for CPP disability. You can submit it online, which is what I would recommend. Explain why the decision's wrong, attach any supporting documents, and get it in there. When in doubt, just submit the form requesting the reconsideration. And if you're still trying to get other documents necessary to support your claim, just don't wait. Get the request for the reconsideration in before the 30 days and tell them more documents will follow, rather than hold off on filing the whole thing because you're trying to get these other documents. That's what some people do, and that you want to avoid that. Just get the request in, fill out the reconsideration request form, get it in, and say more documents will follow. That way you'll meet the criteria of having requested it within 30 days. All right, next part. So what happens during the reconsideration? Once you submit it, it goes back to Service Canada. They'll review it. It can take several weeks. They may call you for clarification. If you've asked for more time to get documents, they'll follow up with you to see how long it might take. As long as you're being reasonable with getting documents and not just like delaying things, that they will be reasonable with you, and you just wait for them to make a decision. Now, the outcome could be that they will reverse the decision. In other words, they'll approve your EI claim, or they'll stick with the original denial. If they stick with the original denial, then your next step is just like with a CPP disability case, you would go to the Social Security Tribunal. There is two divisions within the Social Security Tribunal. One division deals with CPP disability claims, and the other deals with EI claims. So you would go into the EI claim division, and you would file a notice of appeal with the tribunal. You use the form for the EI division, and you must again do this within 30 days. You have to attach a copy of the reconsideration denial letter. Again, you want to include some explanation of why you're appealing. It can be as simple as that you disagree with their decision. You can attach supporting documents, but again, do not delay filing this because you don't have all your documents together. Just get this filed and indicate that more documents will follow, and then that is fine. They will accept your appeal. They'll then contact you about how much time you need to get your documents in, and they will be reasonable as long as you are showing that you're reasonably trying to get the records or information you need. Just do not delay filing the request for appeal because you don't have everything together yet. So the appeal process at the Social Security Tribunal, it's the general division would be your first level, and the EI section of the general division. Most appeals happen over the phone or in writing. You can request in-person hearings, but again, not necessary. I think you can also do Zoom hearings as well. I've never done an EI appeal, quite frankly, but I expect you can do them over phone. It's the same as the CPP disability, over the phone or in writing. You'll present your case to the tribunal member. They may ask questions about your documents, and then after the hearing, they'll make their decision. Okay. Now, tips for a successful appeal. These are pretty basic tips here, but you want to stick to the facts around whatever it is the reason. So once you identify the reason for the denials, be focused on that and stick to the facts that support why you're saying that reason is not correct. It's good to have a timeline and to have some evidence to support what you're saying. It can't just be you in there talking. So if you're saying that, like what's an example? If they say you weren't available, make sure you show, here's copies of the resumes that I sent out. Here is screenshots from the online job market that I was posting things, and you can show things where there's dates. Here's emails that I sent out with dates on them. That's the type of thing you need in order to prove your case, especially when you're at the tribunal. It's very important. Do not disturb. There we go. It's very important that you stay calm and polite, and just let the tribunal member finish their thought before you jump in. Even if you know what they're saying is incorrect, let them finish their thought before you sort of cut them off and say, no, that's like sometimes so you want to let them finish the thought, even if you know it's incorrect. Once they finish the thought, then you can respond in a respectful way to say, I understand why you see it that way, but here is the evidence, and here's the information that I'm hoping will change your mind on that. Again, you can get legal help. So lawyers are available to help with these types of claims, but often the cost of getting a lawyer doesn't make sense in a lot of these cases. So you just have to decide what you want to do. All right, that's pretty much it. So again, decisions can get overturned, sometimes pretty easily. Often they can be overturned before you even have to get to the reconsideration phase, but make sure you file the reconsideration within 30 days if they don't overturn their decision. The deadlines are strict, so if you miss a deadline, that you could lose everything. So acting fast is very important, but if you do miss a deadline, if you have a good reason, then they can extend it. I appreciate you guys showing up for this, and I'll now move on to answering questions from people. All right. So if you have any questions, now's the time you can put them in here. While I'm waiting for questions, I'll do like I usually do and go check out our disability claim forum to see if we got any questions over there that I can answer. And no, we do not have questions over there. For any of those just joining us, we just finished up talking about EI and how to appeal. I'm just now into the open questions for anyone that has some questions about any topic, really. Could be even legal topics that aren't employment or disability law. I'm willing to take a stab at just about anything, even though I'm pretty focused in my practice area to be disability and employment cases. My favorite cases are the ones that really overlap. We do a large number of wrongful employment terminations that involve long-term disability, coming off sick leave, that kind of thing. Those are really my favorite types of employment cases to do, although we do a number of employment type cases. So working a lot today. So with employment cases, just to give you guys some idea of how it works, we start usually with employment cases when people hire us. We will start by sending a notice letter to the employer to say that you've hired us, and it's called a demand letter. So we make a demand for payment. We say that you've hired us. You wrongfully terminated our client on this date. Here's why we say it was wrongful. Here's what we know, that you offered them X amount of money or you offered them no money. We tell them why this amount, a different amount of money is appropriate in your case, and then say, in the purposes of settlement, we'll make a compromise and you can pay this lower amount of money by a certain date, and we will not move forward with any legal action. That will result in probably like half the cases, that will result in the employer doing some negotiation directly with us, either the employer doing it or they will get lawyers involved right away to negotiate before a lawsuit is filed. And like probably 50% of cases will just be resolved that way, going back and forth with the employer, with their lawyers, the cases will get resolved. However, in some cases that won't work. Either the employer will just tell us to buzz off right away, hoping that they count on the fact that some people will get lawyers to try to negotiate something, but not to file a lawsuit. So the employers will sometimes make a calculated guess on whether they think that if they just sort of stonewall you and say, nope, we're not negotiating anything, that you'll just kind of shrug and you say, well, I can't afford to pay this lawyer to go to court, so we'll just drop it. And that does happen. When we take on a case, we will only take on a case if it's guaranteed that we can go to court. So most people hire us will hire us on a contingency fee so that we then can file the lawsuit. And then even employers who have originally started out saying they won't negotiate, once we file a lawsuit or a human rights complaint, that will change the tone of things, and they will often come back and start negotiating. Oh, we got a question here from Sherry. Thank you, Sherry. Let's see what you got here. Sherry is asking, is the standard 120 days now to hear back if you are approved for CPP disability? Do they normally advise the decision by mail or phone? 120 days. Is that 4 months? I believe it is. Yeah, that's 4 months. So that has always been their standard, but it can take longer. Sometimes it's faster, but sometimes it can take longer than that. But I think that is still their standard that they publish and they try to meet. And it does fluctuate up and down depending on circumstances. I've seen it take as long as up to a year to get a decision out of CPP. So that's rare, though. Most times it's going to be within 4 to 6 months. They normally advise you. Often they will call you and tell you about the decision, but you also could get an email. Oh, I'm going to sneeze. Sorry. Normally you won't get an email. I take that back. You will either get a phone call or you'll get a letter in the mail, is generally how it's going to work. You can also log into your My Service Canada, and in there it will show the status of your claim. So you can log into your My Service Canada, and sometimes you'll see the status change in there before you've heard from anybody, so you will know that the case has been approved and you just have to hear from them. There's not any point following up with them for the first 4 months. I would say you could start if you've got to 5 months and you've not heard anything, then that's the time to start following up. Or even at the end of 4 months, you could follow up. But there's not a lot you can do. Once you get past 5, 6 months, now you're getting into a longer period. And once you get past 6 months, that's when I say you can start filing complaints with the ombudsman and all that kind of thing. But just watch. What I recommend is watch the My Service Canada. Now I know that waiting for decision CPP. I know this has been discussed quite a bit online. Yeah. So it's discussed on our forum quite a bit where people post their thoughts in here. You got people here saying, here, I'll just share the screen. This is where I would go to get information like this because, again, this is not, I only hear it secondhand from other people, how long it takes. We do file some cases on behalf of people. Mostly we do appeals, though, but we do file some cases. So here is like this little section here. How long have people waited for a decision? My husband's case has hit 170 days. How long have people waited? It used to be 4 months, but I'm pretty sure the wait has gone up. Now this is in 2019, so fluctuates up and down. So this may not be valid anymore. This is an older. You got people here saying it took over 11 months, but that's unusual. Yeah, people are saying it's had 6 months. Yeah. This person said 180 days, so yeah, that'd be 6 months. But the forum would be a great place to ask that. Let me see. Yeah, this is also an older one. Yep. So yeah, you could check it out on there, but it normally is going to take much longer than the 4 months. So Sherry's saying, oh, you get an error message when checking the status online. Yeah, I haven't heard of that, but that would be super frustrating. I agree. Absolutely agree. Well, just cross your fingers, Sherry, and hopefully it will get approved. We don't know what the current approval rates are. The only time it's ever been studied was in like 2015, 2016, I believe, or 2014, 2015. Anyway, it was back over that period of time. They did a study, an authorized study by Service Canada, and they basically found that 60% of applications were denied and 40% were approved. And then of the 60% that were denied, only a small percentage of those, I think like 30% of those people actually appealed. So if I remember it correctly. So it was I was always shocked at how many people just did not follow through on the appeals. At each step, there was like a major drop off of people just not going any further. And it was shocking to me to see how big the drop off was from each step. Yep, you're welcome. You are welcome, Sherry. Any other questions, Sherry, about your case that you're willing to share online here? Did you end up putting in, like, what did you end up putting in for medical records? Did you end up putting in like an LTD claim file? Did you end up getting stuff in addition to the medical report that the doctor fills out? For example, like, did you send in your family doctor's medical file, that kind of thing? Always interested on how people are approaching it. I don't know if anyone else on here has done a CPP application, but I always like to hear how people go about it. Okay, yeah, you did the LTD claim file. Yeah. Yep, I would recommend that. We get that question all the time. Some people don't want to give it because they worry, like, there is kind of a mindset of like give them the minimal information, that kind of thing. But I'm the opposite. I say give it all. The LTD claim file is often the best way to just give them the whole thing. I will tell you, like, sometimes the LTD claim file will have stuff in there that may not be helpful for you. I would encourage you to leave it all in there. You don't want to get caught cherry picking out information that's bad. That will really hurt your credibility if it's ever discovered that you did that. And sometimes having like contradicting information in there is not terrible. You can always address it, and it does give you overall better credibility before the Service Canada and the tribunal that you would give them all the information, the good and the bad, and then explain why the bad isn't as bad as it may seem. But you use the book. Do I have it here? I don't have it in front of me. That's good. That's good. Oh, it's probably this book here. Probably use this book. This book, and maybe did you use the application workbook? I don't have a copy here. I don't know where all my copies went to. Is that it there? Oh, there it is. Did you use this book here? The application workbook? This probably needs some updating, honestly. When did I publish this? This was published in 2019. Yeah. It's probably due for an update, but when I published this, this was published, I think, before. Was this published before you could file online, or right when filing on? Yeah, I think this was published before you could file online. So I really need to update this at some point to take into account the filing online. Make sure, like, this goes through, this booklet, in case you haven't used it, goes through question by question, and the application changes over time. So this was done when they did the last major update of the questionnaires, or of the application, but I'm sure they've tweaked it since then, so I probably do have to update this. Okay, perfect. So Sun Life sent your LTD claim file directly to them. That's perfect. And you use both books. Great. Now, if you're with Sun Life, I got to believe that they will, if your claim gets denied, Sun Life will probably pay for you to have an advocate work with you on the appeals. So take advantage of that if you can, if they have that option. We do get people asking us about that, like, but you're better off working with an advocate than trying to do it on your own, in my opinion. They'll just have practical knowledge. The range of quality can vary between advocates, but a lot of the ones that are used that work with the major insurance companies are pretty good. Certainly, if you can, I know a company that, an advocacy group that works a lot with insurance companies is, what are they called? It's escaping me off the top of my head here. The Disability Claims Advocacy Clinic, I think they're called. They're very good. So if you have a chance to work with them, then you should have no hesitation, in my opinion. Let me look them up here. Let's look them up. Yeah, these guys here. I'll share my screen. So this is someone who is not a lawyer who owns it, but that doesn't always matter, to be quite frank. I'm more focused on, is it someone who knows what they're doing and has their heart in the right place? And the owner of this company is absolutely on both. Yes, on both of those. So this is the company here. Now, the owner is, let's see, find her on here. Right here, Alison Smith. So, yep, she's the owner of this company. She's very good, very passionate. Got a lot of time for Alison. And you can see they have a big team. They got a big team of people. They all look like pretty friendly people. And they work, from what I understand from speaking with Alison, now Alison used to represent any kind of person who was applying, but they switched up their model a few years back. And they pretty much, from what I understand, they only represent people who are on long-term disability. So they work with insurance companies to represent the insurance company's clients of people who are on long-term disability. It's not something I do, but that doesn't really mean anything. The advocacy clinic people, like I said, I would trust them. Their heart's in the right place. So I would always recommend them if you can get them. There's other ones too. I don't know all the groups that are out there now. I just know this one because of its, like I said, Allison's well known in the CPP disability world. She's been doing this longer than I have, quite frankly. I'm pretty sure she has. Um, and yeah, so I wouldn't hesitate if you can. Some insurance companies don't give you the choice, but if you do get the choice, I would say you should jump at the chance to work with these guys. Yeah, it can be. It definitely is overwhelming to do the application. That's why I did put the book together. Quite honestly, like I want people. Part of the reason I did, well, let's be frank. The reason I did these books is for ultimately to get clients. I mean, I'm not making money selling books. So the whole purpose of me doing these books is to get clients because I represent people for a living. But the other thing that helps with these books is that I would rather people, I'm not really interested in representing people who could apply and win on their own, quite frankly. I'm interested in the more complicated cases where people need a lawyer in order to get approved. So these books, part of the rationale behind these books was to help people apply on their own. And so when people contact us about working, can I hire you to do my application? We really encourage them, like, why don't you use our books, apply on your own. If you get denied, then we can jump in. Now, some people don't want to apply on their own. So we do some applications. I try to do as little as possible, to be honest. But we typically will do the appeals. Yeah, I appreciate the recommendation. We're good. We're good for what we're good for. Like if you have a very complicated appeal and you really are on your last chance and you'd have to give it your best shot, then we are a good choice in that situation. If you want to try to, the other reason to work with a firm like ours is if speed is a real issue, like you want to get approved more quickly. Certainly, it matters that you're paying out legal fees, and that is definitely a factor. But I always like say, look, you got to weigh that against you are going to pay part of your past pay, your retroactive pay to a firm or an advocacy group who's working for you. But if it means getting approved, like that, the future benefits are usually where all the money is. So like any reasonable advocate who's working for you is not going to be taking a cut of your future money. The future money is usually hundreds of thousands of dollars. The past money is maybe $10,000, $20,000, $30,000. It can get higher in some cases, but the majority of the money in value for you is the future benefits, and that you get to keep it all. So you don't want to risk losing the future benefits by trying to save money on the past. It is a difficult spot that people are in. I'd also like, there are free sources out there. Like if you go to, let me just show you here. If you go to the Social Security Tribunal, the Social Security Tribunal actually has let me just share my screen here. They have a list of free services. Now, we're not on there because we're not a free service, but there are free services out there. So I forget where it is. I'm now not going to be able to find it probably. Get help with your appeal. Here we go. Here we go. Or check out our list of organizations that provide free services. So what they've done is, oh, okay, sorry. Let's go back. Let's just go to, let's just say Ontario. So what they've done is they've compiled together all of the organizations that will provide free help to people. And maybe that's the best choice sometimes if you don't want to pay a lawyer or if you can't. I mean, sometimes we can't take on cases for people. So if we can't, we will refer them to these kinds of places. Again, the range of a lot of these places will not have lawyers, but that's, again, you don't always need a lawyer. What you need is someone who knows what they're doing. Sometimes non-lawyers who have a lot of experience in this area are very good. Sometimes they're not. So it's just, and sometimes there's lawyers who do this work who are terrible. So you always, no matter who you hire to represent you, you have to look for some clues around, are they competent, knowing what they're doing? And ultimately, that's what you have to look for. Oh, I'm not even sharing my screen. Sorry about that. I'm just going through this. So yeah, sorry. Here is, I can't believe I just did that. I didn't even share my screen. So here's the screen. I was at the Social Security Tribunal. I'll just show you what I did. I came down here, get help. Then I went here, organizations that can help. Then you just click on the province. So I click on Ontario. And then you can see all the different, by different areas of different organizations that can help. Again, to be on this list, you have to give free services. We're not on this list because we don't give free services, but these are options for people who can't afford a lawyer or who don't want to pay a lawyer and would rather work with a free legal clinic. All right. Sorry about that. Okay. Well, if we don't have any more questions, I'll give it a few more minutes. I see we got more people showing up here. So I've just, for those of you who just showed up, we talked today about how to do an EI appeal if you've been denied EI benefits, so not disability, but regular EI. I talked a bit about filing your CPP application. We were talking with Sherry, who's on here, who's just said she just put hers in and she's waiting. She wanted to know how long the wait is. They say 4 months, but it can be anywhere from 4 months to up to 8 months in the worst case scenario. Well, worst case scenario can go longer, but most often you're going to be between 4 and 6 months or so. You're going to get a decision. She's been having issues with online when you log on. I was telling her, well, go online and watch for your status updates on your My Service Canada, but she's saying she's getting error messages in there, which is very annoying. It is like watching a pot boil when you're the person sitting there like watching your clock every day with no money coming in, wondering when are they going to do this appeal. And so that's kind of the situation a lot of people find themselves in. I was just going over where you can get legal help for CPP disability cases. Like we represent people, but we're a paid law firm. And so there are options for people who do not want to hire a law firm, or where law firms is not practical to hire a law firm. So for example, some cases where you are on an approved long-term disability claim, your long-term disability insurer they have arrangements with certain advocacy firms, disability advocacy firms, who will help you with your appeals and at the tribunal, etc. I was mentioning one of those who I always give a good word in for, the Disability Claims Advocacy Clinic. So I had their website up. I respect their owner quite a bit, and they're a good group. So if you are lucky enough that your insurance company works with them, then you should have a lot of confidence to have them work with you. I'm not saying they're going to be perfect. Nobody's perfect. Everybody drops the ball here and there, but overall, I would be very comfortable recommending someone work with them. There's other groups. I can't speak to all the groups because I don't know the people involved, but I would generally say you're better working with somebody, get an advocate, than not have one. And I was also showing just a second ago, here I'll bring it up again, that you can recommend to other people. If you just don't want to pay for a lawyer on a CPP disability case, the tribunal actually maintains a list of free services. Here, I'll bring it up. So if you just go to this is the Social Security Tribunal's website. You go to their website, on their homepage, get help. They keep a list here of, and you just pick your province. Let's say you're in Nova Scotia. So these would be, there's not much in Nova Scotia. Okay. So these would be places you can get help in Nova Scotia for free if you qualify. So I know with like Dalhousie Legal Aid, that's part of the law school. Let's have a look at that. So they will help with CPP disability claims, or so that says. but maybe they, you'd have to check with them, just make sure they can take on the case and that kind of thing. Oh, I realized you weren't seeing when I clicked on that, but it just showed their website. But yeah, so that's free way to get free help. And yeah. Oh, we got another question here. Let's see what this one is. Let's see what this one is. What's this say? Just like paying for an auto mechanic, people don't want to pay, but to go to work in a car. I am in Virginia. I am in Virginia, USA grad from Regent Law. Enjoy your channel. Oh, thanks. Glad to see you here. Yeah, it's definitely the funniest thing. Like when you learn about legal marketing and how to like advertise for legal services, one of the things you can learn early on is like we offer a service that people don't want to buy. So often, like the best way to sell legal services is to say you can get in and out as quickly as possible, or to focus on the fact that it can get your outcome. It can get you like the only reason people frankly use lawyers is you can get an outcome that you want that you would otherwise be unable to do on your own. So it's like the least of the bad options. Not to say like, you know, lawyers often have a bad reputation, but when you poll people about do you like lawyers in general, people will give a negative thing about lawyers. But when they're asked, do you like your own lawyer? It's like super high. So people like their own lawyers. They just don't like lawyers in general because there's this idea that lawyers are schemy, that they will bend the rules and this kind of thing. That comes with the territory of being a lawyer, because part of being a lawyer is having a duty to your own client to advocate for them, zealous advocacy. So that can often, people can associate negatively with the lawyer, also with their client, right? That's why I have a lot of respect for lawyers who represent criminals and the worst types of criminals, because for our system to function properly, our justice system, even the most guilty criminal who's done the most horrible things needs to have strong legal representation to force the government to prove that this person actually committed this crime. And I know a lot of people will say, but when everybody knows someone's guilty, like why waste the time? The problem is it's a very bad slope to go down, is once you start assuming people are guilty just because that's the vibe and what everybody thinks, and you don't and you let the government cut corners and things, you end up with a place like China, okay, where you just can be put in jail and there can be nothing done about it. So I would not, you don't want a totalitarian state where people could just be put in jail for whatever reason. You do want to have, that's why the most guilty people, you want the most guilty people having very strong lawyers to protect the innocent people who come along as well. Otherwise, the whole system kind of crumbles apart. All right, so you're an appraiser. Okay, right on. Yeah, like it's funny with the number of people who go through law school and just do whatever type of career. It's actually, as you probably know quite well, um, it's really not that many people who come out of law school that go on to practice law, and those that do often get out of law. So it's just there's so many things. A law degree is so versatile. People go so many different directions with it. It's still a good degree to have, but it's absolutely true. If I look at my own law school class, like the number of people I graduate with who are still in like a private practice of law is very low. A lot of them have gone into politics. The current premier of BC was actually in my law school class, which is always funny. The premier of BC. And so some of them have gone on to do things like that. Others have gone into different types of business. But it is funny to see, well, not funny, but it's common to see how many people do not stick in a law career. It's not many. It's not an easy career to do. And there's so many other things out there that, but it does open a lot of doors to have a law degree. I'm sure you've had a lot of doors open because you have the law degree, especially doing appraisals, property appraisals and things. Yeah, property is an area that I don't know much about. I'll get family say to me, "Yeah, you're a lawyer. What can you tell me about this property thing?" I'm like, "Yeah, no." Like I literally taken one property law class in like first year law, and since then have done nothing. So I absolutely know nothing about property law. So the problem with law, like you really have to, as a lawyer, you really have to specialize in a couple areas because otherwise there's just too much and you become like so spread so thin. The most stressful ways to work as a lawyer is to work somewhere where you have to do like multiple areas of law that you only have like a minimal knowledge of each. It makes it very stressful because every time you've got a new case come in, you're trying to like research and figure out, okay, what's the current thing. It's much easier to just focus on one or two areas and do that. Over my career, I've done, like I said, I started out my career doing personal injury law. I was quite passionate about that. Worked in that area for quite a few years, actually. Through law school, I was working summers doing personal injury law. And then I got out of law school and did personal injury law for quite a number of years. Let me think what it would have been. It would have been 2004 until 2011. So 7 years or so, I did personal injury law. Then I left the personal injury law firm I was at. I was kind of like, I wasn't an official manager, but I was really managing a team of lawyers doing personal injury cases. So I was kind of burning out from it, quite honestly. So I wanted to kind of do my own thing. So I left that law firm, started my own firm, where I still continue to do some personal injury law because I had clients that came with me when I left. But I transitioned from that to doing disability cases over the next few years. And by 2013, 2014, I really started focusing almost exclusively on disability cases. And then over time, I started doing more employment cases until I get to the point now where I'm doing a large amount of employment cases, like wrongful dismissal, representing employees only. I do a lot of human rights cases, mostly in the area of disability, but we do all types. We just, I think, I don't know if the person hired us, but we had a very good pregnancy discrimination case, which I was quite interested to represent this person on. So I'm not sure if she's hired us yet, but that's one we were looking at. And a lot of retaliation cases. So a lot of people will get fired. This is big in the U.S. The United States is quite different for employment law with Canada. Canada is way more favorable to employees. But one of the common areas between the U.S. and Canada is these reprisal cases where there's protected areas that employees have, and if an employer does a reprisal, like fires you for because they fired you because you kind of enforced your rights under a protected area, then those are very good cases. We had one of those come in today too. I won't say the details of it, but it's quite an interesting case. I hope the person hires us. But they brought up safety issues and the employer fired them. So you can't fire an employee for trying to bring up safety concerns and trying to work by what the safety is. If the employer fires someone over that, that is a protected area. It will be a wrongful dismissal, and they'll owe the employee compensation. And not only compensation for like their lost wages, but also there can be aggravated, sometimes punitive damages in these kind of cases as well. All right. Just give a few more minutes, see if anyone else has any questions. There are some good, for any Americans that do show up here, there are some good lawyers in the U.S. who do live streams on YouTube as well. There's, his name escapes me, but there's a guy, I think every Thursday night, he does a live stream on Social Security disability in the U.S., which is the same as our Canada Pension Plan disability. He does a good job. He's been at it forever. He does a live stream. He gets hundreds of people on his live stream, but I guess it's the U.S., so it's so much bigger than Canada. So like 10 times, I think, more than 10 times the people. I think about that. Yeah, about 10 times the people, I think. I always joke that Canada is basically the same, less people than California, I think. When you look at it, pretty sure it is less people than California. Although people maybe have been moving out of California maybe to a certain extent, but yeah, Canada is small compared to the US. All right, let's leave it there. I'm glad everyone showed up. I will be back here on Monday, Tuesday, Wednesday next week. I'll be taking the next couple of days off. Appreciate you guys all showing up. If you have any questions, you can always reach out to my firm. if you're dealing with an employment law issue, or like an employment termination, discrimination issue, or a disability claim. That's what we focus on. I wish you guys all the best, and we'll talk to you later. Take care.